Thank you, Billy. So good morning and welcome to everybody. Again, my name's Rich Corsi. It's my pleasure and honor to serve as Dean of the College of Engineering at UC Davis. On behalf of the college, I am excited to welcome you to the 2025 ECE Expo. Before I begin, I'd like to take a moment to thank the electrical and computer engineering team, staff, faculty, probably some students too, for their efforts in putting this event together. Thank you all for your incredibly hard work. So here at the UC Davis College of Engineering, we're guided by our next level strategic vision for research, for education, and for community. The Expo is a wonderful example of this vision in practice. This event provides our students with the opportunity to gain real-world experience presenting to members of industry, to alumni, to faculty, to staff, and to their peers. Experiential learning is a critical aspect of our strategic education vision. Technology is rapidly evolving, and it's critical that students are prepared with the skills that industry needs. To do this requires partnerships with industry to help us equip our students to become innovators and agile leaders who are empowered to better society and the planet through socially responsible engineering. I'd like to thank our industry partners and alumni for their generosity and support of the ECE Expo. Thank you so much. Before I close, I'd like to thank the students whose hard work and creativity will be certainly on display today, and encourage everyone to visit with as many posters as you can. I will after my next Zoom meeting. Ask the students questions, engage with them. These are outstanding Aggie engineers and outstanding future engineers who are going to really make a difference in the world. I'm very confident of that. Now I'd like to turn the podium over to Professor Andre Knesson, who will introduce today's very impressive alumnus and keynote speaker. Andre?
Thank you. So it's certainly my pleasure to introduce Professor Stephen Henderson, the Judge Haskell A. Holloman Professor of Law at the University of Oklahoma, where he specializes in criminal law. So let me just ask the question. So why did we invite a criminal lawyer to speak at ECE Expo? Well, Stephen graduated from the ECE department in 1995 with a BS in electrical engineering with highest honors. And he received the College of Engineering Medal for the most outstanding graduate at the University of California of Davis. So he wanted to know what he did with his life since then, because it wasn't in engineering. So he went to Yale Law School, receiving his doctorate of jurisprudence in 1999. His graduation in analytical writing, like a proposal, like the thesis in a PhD, kind of the same thing, was an extended analysis of the cryptographic proposal for secure communications promoted by the NSA, and then President Bill Clinton, investigating whether such technologies, including law enforcement backdoor of decryption key escrow, could be trusted. So having that impact immediately is absolutely huge, and that's probably put him in the spotlight. So after practicing law, Stephen joined the University of Oklahoma as a faculty member in 2011. He became an elected member of the American Law Institute in 2022, and he's done drafting work for the American Bar Association and the Uniform Law Commission. He co-edited the Cambridge Handbook of Surveillance Law, and he served on various committees working with technologies from fingerprinting and blood splatter to drone flight to body cameras into generative AI. So life is interesting in how connections and affiliations develop as we go through life. Stephen and his brother and his sister grew up in Los Alamos, where their family formed a very close bond with the University of California. Interesting, Steve's brother, Greg Henderson, went to Georgia Tech, where we briefly overlapped because Greg did his PhD under the same advisor, Tom Gaylord, who was also my PhD advisor, of course. And Mark is now the CEO of Littelfuse. Now Steve's older sister, Lindsay, is even more impressive. She's the first female chair of computer science at Oxford University. So Stephen, I don't know.
That's why I had to go into law. I couldn't compete.
So finally, I taught Stephen the most important part of electrical engineering, which is Maxwell's equations. Now, he clearly understood them so well that he can immediately move on to another challenging discipline. In his own words, Steve said, law is the same as engineering. You have your givens, which are your facts in a situation. You have your rules, which instead of Maxwell's equations, are the enacted and judgment laws. And to get you a conclusion, you better reason correctly. So I found electrical engineering an extraordinarily good preparatory program. Welcome, Steve.
Thank you. Thank you so much, Noam.
I could use your chair.
Oh, yeah, you can use my chair. That's the least of it. All right, well, thank you. I don't know if you really know what you're getting into, but it is a real honor and privilege to be here. So thank you so much. I'm going to dive right in. We'll have time for a little bit other stuff after, assuming the AV is all good. Everybody give me the thumbs up. All right, so I want to talk about this first. What does it mean to be an American? We live in a pretty divided time, I think. We feel like sometimes a pretty divided people, so it seems like an important question to get the answer right. Let me at least posit one possible answer, which is to have the rights guaranteed by the first 10 amendments to our United States Constitution. It's not a perfect answer. I don't think you can give a perfect answer to a question like this, but I know you could give a lot worse answers than this one. So it's my privilege as a professor of criminal law and criminal procedure, I get to spend a lot of time thinking about the Bill of Rights provisions and what they mean to America and the world and what they're supposed to mean, what we hope they'll mean. So I spend most of my time thinking about the 4th, 5th, and 6th Amendments because those have the criminal procedure protections. So for instance, we all know them in some measure, right? The 4th Amendment says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And then goes on, we'll talk about this a bit, no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So that's an anti-police norm, meaning that makes police's job harder, right? It's a harder job for the state. So why would we do that? Because, of course, it's a human liberty and dignity promoting norm. So that's what I like to think about in the time. It was forged in our founding experience. And so let's read a quote together. This one's going to be a little long, so forgive me for that, but it's the United States Supreme Court. We'll read it together. It'll set the backdrop of where we got this 4th Amendment, and then we'll talk a little bit more about that together. So this is what they say. And you know, as wonderful as UC Davis is, you need to replace this projector. so that's when next time I come, whenever that will be, Andre will have bought a new projector. But hopefully you can read. We'll read together. In order to ascertain the nature of the proceedings intended by those terms, unreasonable searches and seizures, it's only necessary to recall the contemporary or then recent history of the controversies on this subject. So what was going on at the founding? The practice had obtained in the colonies of issuing writs of assistance to the revenue officers, they're also called general warrants, empowering them in their discretion to search suspected places for smuggled goods. So they could look anywhere for smuggled or uncustomed goods that they thought they might be, which James Otis pronounced the worst instrument of arbitrary power, the most destructive of English liberty, and the fundamental principles of law that ever was found in an English law book, since these writs placed the liberty of every man in the hands of every petty officer, because once again, they could go anywhere they thought those things were, any home, any business, like that. This was in February 1761, Boston, Massachusetts, remember that. And the famous debate in which it occurred was perhaps the most prominent event which inaugurated the resistance of the colonies to the oppression of the mother country. Then and there, said John Adams, later, of course, President John Adams, then and there was the first scene of the first act of opposition to the arbitrary claims of Great Britain. Then and there, the child independence was born. Stirring words. But let's dig under that hood a little bit. There's always more in a human story. Many of the prominent founders were prominently smugglers, right? There is something to this American hustle, whether we like it or not. They didn't like the general warrants or writs of assistance because that cuts into business. And in the words of Emily Hickman, check this out. This is quite telling, I think a different ethos than we just read from the Supreme Court. The Boston merchants did not fear special writs, which required the publication of the informer's name in each case, for the business of informing was exceedingly unhealthful in Boston at that period. right? Very different from what we read in the United States Supreme Court. But that was the reality. So what was routine in England, these writs, became hated and despised in America. And it wasn't because Americans love liberty and the British didn't, right? It wasn't because, primarily at least, the Enlightenment thinking, which is true. The best philosophic thinking of the Enlightenment was sort of there for the taking in the American Revolution, but it's not primarily that. It's at least in significant part that Americans didn't want to pay what they owed to a crown that was now a long distance away and which distance had strained allegiance. So here's the little nice demonstration of that.
This was a 7-year-long major global conflict, which Great Britain...
We need some audio, maybe?
This was a 7-year-long major global conflict, which Great Britain won. At the peace negotiations, Spain gave up Florida, while France gave up all of its territories in North America. But Britain's victory came at a cost, a £60 million cost. They were now broke, in a lot of debt, and had to come up with some way to repay it. So they went to the colonies and said, okay, listen up. So a huge part of the war was spent protecting you from the French, and now we have no money because of it. So... I'm not sure what you're saying here. Okay, so we spent a lot of money protecting you from the French, right? Right. And now we're broke. That certainly is a pickle. Listen to me. We spent all of our money protecting you, and now we need money. Can you please pay us back some money? No.
Okay, right? Yeah, that's real history, right? When you show kids that, they actually find it's fun. Check this out. So that February 1761 day in Boston, Massachusetts, when James Otis sparked our whole revolution, well, James Otis, this was in Paxton's case, a case called Paxton's case, and James Otis took that case for very personal reasons. The judge in the case was sitting in the role that James Otis believed should have gone to his dad. The families hated each other. It was a classic family feud. In fact, when that guy got that job, James Otis vowed he was going to burn the province to flames to get back. Metaphorical flames, to be sure, but nonetheless, that's what was going on here, right? So he takes the case because what better way to tie this judge to something now disgraced, these warrants, and that's what he wanted to do there. So that's why James Otis takes that case. Why do we know about the case, this James Otis? Remember again, it was in Boston, Massachusetts. We know about that because John Adams was in the gallery that day taking notes. Those are the only notes we have of what Otis actually said that day. And later, as ex-president, so now having been president, John Adams made a sustained drive to make that James Otis speech the spark of revolution. Why did he do that? Because credit at the time had begun to go to Patrick Henry. You remember the give me liberty or give me death guy? And if you've watched Hamilton, you know why this matters. He was from Virginia. Not happening, okay? I'm not making this up. I bet I have some doubters out here, but check out this letter by John Adams written in 1818 as he's trying to rig the historic record to favor James Otis. As the accurate Jefferson, of course of Virginia, has made the revolution a game of billiards, I will make it a game of shuttlecock, which is a forerunner to our badminton, to the extent anybody still plays that. Patrick Henry might give the first impulse to the ball in Virginia, but Otis's battledore, which is the racket they're used in this game, had struck the shuttlecock up in the air in Massachusetts and continued to keep it up for several years before Henry's Virginia ball was touched. Jefferson was but a boy at college, of 15 or 16 years of age at most, and too intent on his classics and sciences to know, think, or care about anything in Boston, Massachusetts. When Otis first fulminated against British usurpation, Jefferson knew more of the eclipses of Jupiter's satellites than he did of what was passing in Boston. But a boy at college. So that's the reality. But you know what? None of that made its way into the Supreme Court opinion that we've read, which reads a lot more like a patriotic bedtime story. So which one is true? Well, I'm a lawyer, right? We are the profession that does not hesitate to debate what the meaning of the word is. So guilty as charged. So it may seem when you have a lawyer come that every answer is always, well, it depends, right? Maybe, both. But I submit to you here in the human story, these are both true. The Supreme Court's desire for human dignity, for human liberty, what we aspire to as a people still today, and certainly what the founders aspired to when they formed this country, is true. But so is James Otis's family feud, so is John Adams' enormous ego, right? And everyone else that was involved in that story. So that's what I get the pleasure of doing here today, or sharing some stories. First, I thought we'd share a story about the Fourth Amendment and technology. It is a story that's hit a critical inflection point, but still much has to be written as well. Then share a story about criminal adjudication and what is to happen, or maybe what should happen if we achieve truly intelligent machines. Then I will tell you a little bit about my personal journey, to the extent it's interesting at all, as I came here to Davis and had some great professors, two of whom I have right in front of me here today, and that story. And then we'll end with a story about lawyering itself. Why does everybody hate lawyers? Okay, so you got to wait till the end, but we'll talk, we'll talk about that then. So first of all, but first, before I do that, yeah, some thanks. So thanks so much to Chair Islam and everyone, to the entire faculty for this great honor. It's a tremendous honor to me to be here. I have a different career, and as I said, it does somewhat feel validating because it's a mix. You know, I'm not quite a scientist. I'm not quite a real scientist. I'm probably not quite a real lawyer either. So I get to mix it up, and this is a tremendous honor, so thank you. And thank you. Two people who wrote letters of recommendation to me for law school are sitting right here. So that's a tremendous honor. Both Andre and Richard Spencer both wrote letters for me. In fact, were my letters from UC Davis. The other one was from my employer, Bruce Robinson, at Lowell's Alamo National Laboratory. So it's thanks to you guys. I mean, to the extent that I have had a bright future at all, you guys played a key role in that. So I thank you very, very much for it. And my best Davis buddy is also here today. She was my best friend before Davis. She's my best friend ever since. She will be my best friend always. So my wife, Hillary, is also here. So thank you for everything. All right, so those are some thanks. Let's get to it. Back to the Fourth Amendment. As Andre already said, in engineering, Maxwell's equations guide the way. They may or may not be a good idea, but so far as we know, for now anyway, they just are, right? So we take them as our givens. Well, as Americans, we have to do the same thing with what the Supreme Court says. If 5 justices of the United States Supreme Court say it, as to our federal Constitution, so it is until you can convince 5 of them to say it differently. That's what it means to be supreme, right? Or, if you want a little more lawyerly, that's what it means to be the court of last resort. And the United States Supreme Court is the court of last resort for our federal law, certainly including our constitutional provisions in the Bill of Rights like the Fourth Amendment. So here's the question for students. Do we have some students in here? In the back, of course. Right, okay, yeah. You should have just stormed the breaches here and taken these faculty positions. But no, it's great. All right, but here it goes, students, because this is what you came for, right? Look at this guy. He looks up to something, right? Doesn't he look up to something? So here's what we need to know. We need to know whether the Fourth Amendment restrains Professor Knudsen in his classroom. Now, traditionally, it would not have, because those founders were not worried about the states, right? They were worried about this new federal government that they didn't want to look like the one over in England that they had just, gotten rid of. So the Bill of Rights were only written to restrict, of course, the federal government, but then we had more history, right? We had a civil war in this country, of course, and in the 14th Amendment, one of the Civil War amendments is interpreted to apply all of those provisions as against the states. So since he is an employee of the state of California, just like I am, an employee, feels weird, but of the state of Oklahoma, so I am too a government officer when I'm doing my job, in some sense. So I'm restricted by the Fourth Amendment, he's restricted by the Fourth Amendment. So, say you're hanging out in ECE 130A, which some of you have probably done here, right? Introductory Electromagnetics 1, which I love, by the way. It shows what double E, right? It's not only introductory, but it's also only number 1. And it's only A, so it just shows there's a lot to learn that's still going on here. All right, so you're hanging out in Introductory Electromagnetics 1, but you're kind of hanging out in your own world, right? We all understand this as professors too. So he takes a little umbrage at that. So in old school, when I was here, he would have picked up a piece of chalk, but I suspect you don't have any chalk anymore. So yeah, he'd have to pick up a marker. There's a little more ballistic, a little more force to that thing, right? Right? So say he picks up a marker and gives it a good throw and smacks you in the head. Fourth Amendment violation? Well, what would you do if you're an engineer? You got to know your rules, right? You got to start with the rules and then you apply, right, what the situation is and see what your rules. Same thing in law. So we have the text right here. It only applies to Fourth Amendment if it's a search or a seizure. I mean, what's he searching for? Your attention, I guess, but that's very metaphorical. That doesn't sound like what these founding general warrants were about. And he's not really seizing your person. I mean, you're every bit as much free to get up and leave. There may be consequences to that, but there's always consequences to just getting up and leaving classes, potentially. So it's not, right? It doesn't sound like this would be a Fourth Amendment event, and that's fine. So a lot of things that government actors do will not be Fourth Amendment searches or seizures. But that has had an outsized role when it comes to technology. So let's tell that story, share it together. It starts way back in 1976. United States versus Miller. So Miller was in the moonshine business. And when you're in the moonshine business, you don't like to pay your taxes, right? So he didn't pay tax on that income. So the government wanted to prosecute him for that tax evasion. So they needed to be able to prove that he was earning income on which he wasn't paying tax. Kind of maybe hoist him by his own petard. What if we could just get his financial records? So that's what they did. They went to his bank. They obtained his bank records. Lo and behold, he's earning cash. He isn't paying tax. We now have him for that. Well, moonshine, now defendant Miller said, hey, you couldn't do that. You shouldn't be able to do that. You needed to get a warrant before you got my bank records, and they didn't. Okay, let's see whether they needed a warrant. What's the Fourth Amendment say? No warrant shall issue, but upon probable cause, which is a level of suspicion, supported by oath or affirmation, and particularly describing the place to be searched, here the bank, and the persons or things to be seized, those records. Notice no more general warrants, no more writs of assistance. So that's what the founders were thinking of. Okay, fine. So if cops want a warrant, they have to have a level of suspicion that meets probable cause. They have to swear to the facts are true, and they have to describe particularly where they're going to look. But that doesn't say whether they need a warrant or not, right? It just says if you need a warrant, you got to do A, B, C, but it doesn't say when you need a warrant. So that's why you still got to come to law school, all right? Because we're not going to be able to solve that whole riddle here today. But here's what the Supreme Court said in this case. We find that there was no intrusion in the area in which Moonshine Miller had a protected Fourth Amendment interest. A bank depositor takes the risk in revealing his or her affairs to another that the information will be conveyed by that person to the government. The Fourth Amendment does not prohibit the obtaining of information revealed to a third party, here the bank, and conveyed by that third party, the bank, to the government authorities, even if the information is revealed on the assumption that it will be used only for a limited purpose, here banking, and that the confidence placed in the third party will not be betrayed. So this is today known, sensibly enough, as a third party doctrine. You retain, says the Supreme Court, no reasonable expectation of privacy in what you give to another party as to the government getting it from that other party. That's the rule. All right? So we all know the rule, so now we can all be lawyers. Same as engineering. Once we know the rule, we just have to apply it to some new facts. The next time this came to the Supreme Court was 1979, Smith v. Maryland. Now, Smith was a robber. Are criminals smart? Most criminals. Are most criminals smart? No. Thankfully, right? Because that's why we catch them. Okay. Well, Smith was no exception. So Smith had robbed this woman, Patricia McDonough. He might have gotten away with it, except he took to calling her on the phone and telling her he was the one who had robbed her. So that gets your attention. And ultimately, they track this guy down, and now all they need are the phone records from the phone company that shows he was the one calling her house, because, of course, they didn't even have cell phones back then, right? So he's calling the house, so we just need his phone records to show he's admitted he's the guy. So they do that. They go to the phone company, and they get the records. Any Fourth Amendment restraint? Does he know that his phone company knows whom he calls? I see some heads shaking. I mean, it is interesting whether or not he knows how phone technology works. But back then, remember in the day, this is ancient history, right? So we used to get phone bills, and they actually came in the mail, real mail, right? Like this thing that used to happen. And so, right, you'd get that. In all long-distance bills, we were billed by the call. So that's why my mom was always running around, get off the phone, you know, because it costs money when you're sitting on the phone. So I know it's a different day, but that's what the Supreme Court thought. Everybody knows that the phone company knows who you call. This is what they said. All telephone users realize they must convey phone numbers to the telephone company since it's through telephone company switching equipment that their calls are completed. Now that's their view. Some people might have had a different view. Did you understand the technology? Do you need to understand the technology? But that's what they went with. Third party doctrine. Okay, so what does that mean for Fourth Amendment privacy in the information age under that rule? We basically have none, right? Zip, zero. I mean, my house is protected by the warrant requirement, but my information that's private is not in my house anymore, right? It's with all these companies that know everything about me. We could list a whole host of companies, right? All the bastards that know everything about Stephen Henderson, and they're not in my home. And the third-party doctrine says that the government can go without any constitutional restraint and get all that information from them at any time. They don't need a warrant. So they don't need probable cause. So they don't need oath or affirmation. They don't need particularity. They don't even need a reason. Mere whim will do as far as the federal Constitution is concerned. That doesn't make me secure in my person. House, okay, that one's all right. Papers and effects. This rule may have been wrong ab initio from the beginning. There were justices, Brennan, Douglas, Marshall, who dissented in those cases. But whatever the case in the 1970s, it's absurd, I think, today. There's no way angry James Otis, right, even those Virginians, Thomas Jefferson, Patrick Henry, John Adams, any of those proud founders of this country would have accepted this rule where we basically have no privacy in all of our most private communications and the like. So I spent years trying to change this rule, like other scholars as well, but decades writing paper after paper, trying to create a better rule that courts would actually accept. Not going to go through that, of course, today, but let's just highlight 2 points that I think will be of interest. The first came in 2012, United States versus Jones. Jones was in the illegal drug business, and the government believed that to be the case, so they wanted to track his movements to be able to prove it. So they put a GPS tracker on the vehicle he was driving, tracked his movements for 28 days. Let me ask you this. If you want to convince somebody of something, maybe you need a little more funding from the dean who left, or from the chair, or somebody else. Anybody you need to convince of something. Do you want to convince them how much it means to you? Or might you do better if you convinced it how much it means to them? There is no interest, my friends, like self-interest. So check out this. This is from the oral argument in the Jones case in the United States Supreme Court. The print will be too small to read on this projector, but you can just listen, and you'll hear the justice questioning the government attorney.
And Fourth Amendment law.
Do you think there would also not be a search if you put a GPS device on all of our cars, monitored our movements for a month? You think you're entitled to do that under your theory?
The justices of this court?
Yes.
Under our theory and under this court's cases, the justices of this court, when driving on public roadways, have no greater expectation.
So your answer is yes. You could, tomorrow, decide that you put a GPS device on every one of our cars, follow us for a month, no problem under the Constitution.
Well, equally, Mr.
So that's Justice Roberts. I'll stop it there. That's how you lose 9-0 before the United States Supreme Court. And that's exactly what happened. Not a single justice bought what the government was selling, even though they were relying on previous Supreme Court cases. They were absolutely solid on the law, but it doesn't matter, right, when something like this goes down. So that's a good thing to remember. The second case that was the kicker here, really the inflection point, came in Carpenter v. United States in 2018. Carpenter was also a robber, like Smith. He was also not smart, so he was busy stealing cell phones, which is like what he liked to steal from T-Mobile stores, and he was, of course, carrying his cell phone, right? And it was on. So naturally, the government now wants to go to his cell phone provider and get his cell site location information to show that he was at those robberies. Any restraint under the third-party doctrine? It is interesting because you could carve this different ways, as so often. You could say maybe people don't know how phones work. Maybe people don't appreciate how the cell phone works. But let me say this, we're engineers. How the heck are you receiving a call if they don't know where you are? Trust me, they're not sending all your calls to Greenland, right? I mean, they're not sending that to every cell tower in the world just hoping you'll happen to be there. That would not be an efficient use of spectrum space, right? That would not work well. So they know, of course, they do know where we are, right? Your phone is pinging that nearest tower, right, all the time. So from that theory, there would be no protection. But who are the 5 most important people? If you count to 9, even better, but you need 5 most important people in the United States who carry cell phones? The justices of the United States Supreme Court. So gone in Carpenter was the third-party doctrine, but only for cell site location information. Law changes slowly. I mean, this is 2018. We've been carrying cell phones for a long time. But law is a conservative field. I don't mean conservative in the modern political sense. I mean in like the Burkean sense, if you know any of their political philosophy. It moves slowly, and that's not always a bad thing. But in any event, so this was a major inflection point in the law. A lot of us have been working for this for decades, trying to get to this point where finally there was some constitutional protection for some information in the hands of third parties. Because look, now it's all details. Right? We might dispute which information is protected, how long it's protected, etc. But this is what we needed to have happen. And so that was a really happy day for those of us who are geeks and do this all the time. Okay, so that's a little taste of the Fourth Amendment. We don't want to get boring here, so now we're going to move to another topic, criminal adjudication and AI. So one of the classes I teach to my law students is criminal law, which is a 1L course. We call them 1Ls. It just means first year, freshman, right, undergrad. So in law school, if you're 1L, you have to take criminal law. And one of the things we learn in criminal law, of course, is criminal homicide, killing people. You can't avoid it. It might be macabre, but it's the world I live in. So we're always talking about killing people and other bad stuff. But in any event, one of the crimes you have murder, you have voluntary manslaughter, you have involuntary manslaughter. Well, so when we're talking about voluntary manslaughter, I teach this case of People v. Bissett, who may once have been People v. Bisset, but I don't know the guy, so I call him Bissett. I just go for it, anglicize it. So anyway, Bissett was around in Illinois in 1910 in Chicago. And the case starts like it's like a joke. So two plainclothes police officers walk into a saloon in Chicago, and they just start chatting up the patrons. And you couldn't make this stuff up. He's like, "Why are you talking to me? I don't know you from Adam." He literally says that. And the cop, undercover though, says, "Yeah, but we could, so let's have a drink," etc. So everything is going sort of strangely friendly, but friendly, until this happens. Cop grabs over one of Bissett's pockets, and the two of them circle and scuffle across the room. It's not pretended by any of the witnesses to the event that they heard all that was said between those two. But it's clear that the officer said to this patron Bissett this: "I want what you have in your pocket. You know what I mean. I eat those things." Now, Bissett was packing. Okay, he was packing heat. He was carrying. And that's why things go tragically south that day. That's why we're teaching it in criminal homicide. So, of course, I always assume this means the cop saw the gun, right? The cop saw the gun, and he was being kind of tough and macho. "Give it to me, I eat those things." So that's how I teach. But this year I had a student shout out, "No, that was not right. That is not what he saw in his pocket." You got to be careful. We know as teachers, we don't know everything. Okay, like what did he see in his pocket? Student says, "A potato." I'm trying to frame this. I mean, why does the cop want the potato? I'm really confused. So where'd you get that? We know it's coming. ChatGPT. Okay. So I said, okay, fine. I'm going to go ask ChatGPT. So here we go. And we know this is not a real test, but I think I'm using this for another reason. In the case of People v. Bissett, I asked, what did the cop mean by "I eat those things"?
This was likely a colloquial way of expressing that the officer was experienced in handling such situations and was unfazed by the suspect's actions. Essentially, it suggested confidence and a lack of intimidation, implying that dealing with resistance was routine for him.
Now that's a pretty good answer. Notice what it didn't say. It didn't say what it was. That's probably a filter. I'm a crim guy, so these things annoy me like crazy. You know, I love some of this generative AI, but you try to get it talking about bank robbery, and it goes all fairyland on you, you know, as if that stuff doesn't. Because those are the filters. Okay, I get it. People want content filters, but it has a real impact for that. So I think that's why it doesn't mention the word gun, but they got a pretty good answer. All right. Well, I say somebody thought it was a potato.
That's an interesting take. If someone thought the phrase "I eat those things" referred to a literal potato, they were likely interpreting it too literally. The officer wasn't talking about food. He was using a figurative expression, likely meaning that he was accustomed to handling situations like the one he was in. But now I'm curious. Where did you hear that someone thought it was a potato?
Oh, she's curious, right? So I have to satisfy the bot. Of course, it was in my law school class.
That's hilarious. Law school discussions can take some wild turns, but imagining someone genuinely thinking the officer was talking about a potato is next level. Did the professor let it slide, or did they pause the class to unpack that interpretation?
Well, I'm the professor, right? So naturally, I didn't let it slide, and the student claimed he got it from you, ChatGPT.
Oh, wow. Busted. I can assure you I never told anyone that the cop in People Bissett was talking about a potato. But I have to admire the sheer creativity or audacity of that student's defense. Did they double down on it, or did they eventually admit they might have misinterpreted things?
They definitely stuck to blaming ChatGPT.
I respect the commitment, but I must protest my innocence. No potatoes were involved in my analysis of People v. Bissett.
All right, I'm gonna stop it there. I did challenge. Of course, it has no memory. We know these things. I asked it, you can't know. You know, and it did a good job on those too. I mean, it was quite an impressive discussion. So I'm gonna stop the discussion there. But this is what's causing people to wonder. Now, we have the real brains here, so I'm not going crazy on anybody. But this caused certainly the public to wonder, might we achieve, right, artificial general intelligence, which is the holy grail of AI, right? This is general intelligence, right? Machine intelligence that's as smart as a human across the entire spectrum of human intelligence. So it can talk to you about William Faulkner. It can talk to you about Daryl Dixon. It can talk to you about whatever you like, right? It can write crime poetry. It can write, any other type of poetry. Is there crime poetry? There should be. It can write whatever you like, right? It can solve mathematical proofs. It can write great Python code, right? It can make podcasts. I'm sure some people go to Notebook LM, which is Google's podcast generator, which is quite impressive. If you haven't used it before, maybe it just shows how samey all our podcasts are, but it's still pretty impressive, right? So AGI is when machines can do it all, including our emotive and social intelligences. And that's fascinating because we may say, well, AI is just faking it. Those transformers don't know to be curious, right? They don't understand what that means. But do you? I mean, look, philosophers have been debating that since there have been philosophers. So we don't know. So it's going to be hard to fish this all out. But like I said, deep breath. I'm not going 2024 AI hysterical on you, right? We have all these AI winters, and then we have the AI springs, and we all get excited again. I get it. But it's still exciting. It's still interesting. So I want to ask the what if. All right? So whether or not you think it's going to happen, what if we did achieve machines as intelligent as humans across the entire spectrum of human competence? Then in what spheres should we retain human judgment? Because if it's consequentially worse in every way, and it will be worse, because even if they're just as smart, assuming they don't become petty like we are, because we are petty. If you look at like parole decisions over the day when people don't eat, they start getting less and less, letting people out. Then you have lunch. I'm feeling much better. Now people get out, right? I mean, unfortunately, this is how we humans behave. So assuming that machines might behave better, they'll be better, right, than we are in consequentialist ways. So is there any reason to so-called keep humans in the loop if we actually achieve this sphere? Take a criminal jury, right? If a criminal jury is just deciding historically what happened to whom when, I'm going to take the intelligent machine. But if it's making a moral determination, then I'm not sure. But of course, now you need to tell me what moral determination is it making. And philosophers have been debating this since there have been philosophers as well. Anaximander was a philosopher in about 600 years before the Common Era. We only have one little fragment of Anaximander's philosophy. In fact, it's kind of cool because it is the oldest surviving fragment of any Western philosophy. And in that fragment, Anaximander talks about recalibration. That in this life, in this universe even, we constantly need to recalibrate. So when something is taken, it has to be put back in equal measure. So is that what criminal juries do? When, there's been harm, there's been wrong, so we need to put back goodness or pain or whatever you're exchanging for it in equal measure? That's one theory. 300 years later, though, this guy Aristotle, sure we know that name, right, came along, and Aristotle said, no, that's not right in criminal justice. In criminal justice, you need to give equitable, particularized criminal justice that is particularized not only to our laws that we humans have happened to write at the time, but also to the defendant, and not just to what the defendant's frame of mind is at the time of the crime, but to the defendant's whole life. Because the whole defendant's life, two defendants are not the same, and you do wrong if you treat them as such. So particularized, equitable criminal justice. Well, then 300 years later, just into the Common Era, this guy Seneca comes along, who was a Roman Stoic, and Seneca says, now you look, if this world is so full of evil temptation, that if we made it out even Aristotelian particularized equitable justice in measure that people deserved, we would become the very monsters we are trying to punish. In other words, for Seneca, moral punishments have moral costs for the judge, for the giver. So which is it? Is it Anaximanderian recalibration? Is it Aristotelian particularized criminal justice? Is it Senecan mercy? Well, we tend not to ask, but if we're about to have a fourth option, the intelligent machine, we may have to know. So in my more recent writing, a lot of what I've done is try to suss this out. What is there, if anything, that is important about human decision making? And I believe it's this. In at least certain spheres, what's important is that human decision making should be role reversible. Certainly applies in the criminal justice system. And what I mean with role reversibility, this is not going to sound new to you, but I think it actually is quite fundamental and quite important, is that there is a genuine reversibility of position between those who judge and those who could be judged. The least differences between the people, the more role reversible it is. So what I'm saying here is that but for circumstances, the judge could be the judging party and the judging party could be the judge. They could swap seats. They are legitimately, realistically, reciprocally vulnerable to the same judging structures. If you think about history, that is not the way most governments have run, right? But if you think about the jury, it's an astounding thing that that is what the criminal jury is supposed to do. So what does that do when you have this role reversibility? Well, that makes the person confront the judge that but for the grace of God, that could be me. Or if you don't like the theistic reference, Phil Ox has got your back, but for the grace of fortune, whichever you like, right? But for the grace of God, but for the grace of fortune, that could be me. And when you do that, you, in essence, judge yourself in a real sense. And that critically, I believe, democratizes judgments, that makes them intrinsically better in the same way that a democracy is intrinsically better than a monarchy. Results be damned. I don't care how good a monarchy it is. I'll take the democracy. And I believe the same thing here. Now, if that's right, we ought to have criminal juries in this country. The reality is, I don't have time to go into it, Dave, but we don't. 98% of criminal convictions in this country are guilty pleas. So you, the people, don't mete out the criminal justice in this country. Massive problem. So a lot of my other work is trying to get people back into what's a realistic way we could get people back into our plea-dominant criminal justice systems. But for today, let me just do one thing with this role reversibility, because we do have limited time. Let's talk about the defense attorney. What are defense attorneys for? Well, in this case, because could we have defense attorney robots, right? That's my question. So what are they for? And in this case, we have a great definition by Henry Lord Brougham, this guy in 1820, who said this: "An advocate, by the sacred duty which he owes his client or her client, knows in the discharge of that office but one person in the world, that client and none other. To save that client by all expedient means," meaning all legally expedient means, "to protect that client at all hazards and cost to all others, and among others to himself, is the highest and most unquestioned of his duties. And he must not regard the alarm, the suffering, the torment, the destruction which he may bring upon any other." Strong words. This case, Henry Lord Brougham was defending Queen Caroline of Brunswick. She was charged with treason by committing adultery against the king. His defense, turns out the king is no king. If the king's no king, adultery is no treason. So he says, hey, if I'm going to send this country into chaos to defend Queen Caroline of Brunswick, so be it. That's what a defense attorney does. A friend of the friendless, and I'll talk more about that if anybody's interested in it. But in any event, so that doesn't have any judging. Defense attorneys don't judge. They do a lot of complicated things. We won't go into them all in the interest of time. But to be a zealous advocate is complicated, but an intelligent machine could theoretically do all of them, which is a tremendously hopeful thought. It may sound odd to people, but we have drastically underfunded and therefore less than competent defense, criminal defense in this country. It is a massive social problem, whether we like to confront it or not. There are other social problems too. I get that. But this is one of them as well. And so for me, that's an incredibly hopeful thought. If we could have an army of truly competent defense attorneys ready for any one of us when we get accused, rightly or wrongly, that's a good thing. Prosecutors, judges, not so much. I won't go into the interest of time because they do judge, but I am tremendously interested then in how we could leverage smart machines to lessen the moral load that they should be carrying if they were to do their jobs in the right way. But I don't want to spend too much time on that because I promised you 2 more stories and my time is running short. So first, just very briefly about me. I certainly won't dwell on this, but it's kind of fun because it's ancient history, right? History goes so fast. My dad was a physicist at Los Alamos, and so we bought our first home computer in 1984, a Heathkit. I don't know if anybody remembers these Heathkit computers. My mom did because the Heathkit cost $3,500 in 1984, and she was not happy about this hunk of junk that cost that much money. That's about 10 grand, right, in today's money. So it cost 10 grand, and this is back when floppy disks, right, were actually floppy, the good old days for some of us. In any event, that was my first computer. He took to programming some cool stuff in ZBasic, and I started learning to program some ballistic alternatives in ZBasic. And then by '89, I remember this well, I was a sophomore in high school, and I was taking that AP computer science class, which back then was in Pascal. So programming away in Pascal. By this time, I was programming my dad's old laptop, which is this, right? This little brick, this Toshiba T3100. That little orange screen, and I spent many hours together writing programming. Number 2, I remember it because this is a day we didn't just get rid of things that break, right? No, we weren't going to do that. So its fan had died, and it indeed would overheat if you ran it. So we took an old hairdryer, put it on the cool setting, duct taped that baby to the back of this, and yes, I ran the hairdryer while I programmed. So that's kind of strange, and old school, but it worked, and that's why it was his old laptop, I guess. That's why I was allowed to use it. And also, for you people, some people may remember this guy came out. Never got any better than this. All right, Castle Wolfenstein. I didn't get all those colors. I was just shades of orange, but it was still terrific. Okay, so that was back then. Next summer, I had a couple formative experiences at 2 national laboratories. Lawrence Livermore National Laboratory at the time ran this Department of Energy honors program where they took a student from each state. We got to go live at the laboratory with a host family for 2 weeks, hang out, work on their computers. It was a lot of fun. This is very funny to everybody modern because your computers are so darn powerful. I was working on the Cray 2, which I'll show you here in a moment, the world's fastest computer at the time, and this is like what I generated. Okay, so I was a high school trumpet player, but ray tracing was hard, man. We couldn't just tell the AI to make the image for us, you know. So back in the day, it took some chops to make a silly little trumpet. All right, so that was my project. Mostly, of course, it's a great program, so I remember hanging out, playing basketball and volleyball, and I thought those shorts were just the thing to pose with the Cray 2. I assure you, that was the height of fashion, man. I was all over it. Not. Okay, but that was the world's fastest supercomputer at the time. Then I went back to Los Alamos National Laboratory, and I started programming in Fortran on their finite element heat and mass transfer code, which was a lot of fun. Hender, my Unix handle, still has some code and some comments in there. May they never die. So that was a good time. Then I came here to Davis in 1992. Good times here. Spent 3 years and a quarter here. I was kind of going fast through, but I had some wonderful professors, some wonderful experiences. As I said, my wife joined me the next year. She wasn't my wife then, but girlfriend, and then became my wife. And then you just let the days go by, right? And it's remarkable. Some of us have done this. Some of us will be doing this. And boy, does time change. So now we have 5 beautiful children of our own. They tried. They really did try. 2 of them went. They did quantum. They have masters in mathematics, and they did quantum and cool stuff in quantum and AI. But I do have to report they are now law students at the University of Chicago. So, so apparently the apple doesn't fall far from the tree. But they'll do some cool stuff in tech law. The other 2 are undergraduates studying finance, and the little guy, like me, likes video games and playing football and doing school only when he must. But he'll get there. He's a good kid. That's exactly what I think he should be doing. All right, so at this point, I could give you a little advice, but we have to remember Steve. Instead of giving presents this year, Steve has decided to give everyone his opinion. You know how well that goes, right? So I'm not going to give any advice, but Steve does have some great lines. People say, this is Steve the Otter. You can check him out on Facebook if you want. People say nothing is impossible, but I do nothing every day, thought Steve proudly to himself. Okay. So I'm not going to give any advice, honestly. But very seriously, if there is a student out there or whatever who maybe wants a different career path, who interested in anything in criminal justice, or we just want to chat about anything, I would love to do that. I'm around all day. I really look forward to it. But I promise you, in my last minutes, a story about lawyering. I said, why do people hate lawyers? It's downright biblical to hate lawyers, right? So we know they do, but why do they? Well, this kid has pretty much figured it out. So what you're saying, Dad, is that when a person has a problem, they call a lawyer like you to fix it. If you fix it, you get a lot of money. But if you don't fix it, you also get a lot of money. Right? That's what economists call rent-seeking, right? So you engineers, you seek to expand the pie of human happiness, right? You do. So give yourself a pat on the back for that. That's good, right? You seek to make what economists would call Pareto superior moves. In other words, you are seeking to make at least one person better off, and it makes no one worse off. And that's a good thing. Whereas the kid sees lawyers as just shuffling around who owns which piece of pie and taking a healthy bite, right, in the process every time. Wasteful transaction costs to economists. Now, it is not worthless because it does make for great lawyer jokes. So just very quickly, a man went to see a lawyer and asked what her least expensive fee was. She replies, $500 for 3 questions. Isn't that a lot of money for 3 questions? You know what's coming? Yeah, what's your final question? So that one's good, right? Just one more. The man looked at the check he received after winning his suit against the city. Pardon me. Wait a minute, he said to his attorney. This is only 1/3 of the amount I won. That's right, said the attorney. I take the rest. I was the one hurt, of course. But I provided the intelligence required to build the case, the expertise to find the precedents, and the oratory to convince the jury. Any ass could fall down a manhole. Okay, so there's some good attorney jokes out of it, but it's not the whole story, is it? There was this guy, Thomas Hobbes. And Thomas Hobbes, if anybody's read Leviathan, you know Hobbes. If you haven't read your Leviathan, I'm going to prove to you, you still know a little bit of Thomas Hobbes. Thomas Hobbes was about as grumpy as he's looking there. And so he spent his time thinking about what would life be like in the state of nature, right? He says, we got these governments. Some people like the government, some people don't like the governments. But what would it be like in the state of nature? And in a lot of pages, he basically concludes that in the state of nature, we'd spend all of our time trying to beat the crap out of each other. Right? And I know he's right because I've watched all 11 seasons of Walking Dead. Now, anybody watch The Walking Dead? See, good. A couple people at least. All right. So you know what I'm talking about. But seriously, take this seriously. No joking. Like, all jokes aside. Imagine your best case state of nature day. You've gathered enough food, you're happy. You have enough shelter, you're happy. You even have some loved ones that have the same. Life is good. What's the one thing you need to do to make sure you'll have it tomorrow? You need more power. John Dutton, any Yellowstone fans? I don't know. I didn't like it at the end, but it was good for a while. John Dutton had this one right, though. John Dutton says, look, as soon as you get anything in this life worth having, someone's going to try to take it from you. And it's true, okay? So that's what we lawyers do. It's not perfect. It's not always pretty. Hey, there's some pretty bad engineers, too. Right? There's some good cops, there's some bad cops. There's some good engineers, there's some bad engineers. There's some good lawyers and the bad lawyers. But it's wrong to think we're just about rent seeking, right? What we do is we maintain the vastly better, even if still somewhat sucky, world with law. All right? And you can thank us later. And that's all I got. Thank you very much. Do we have some time for Q&A or? Oh, good. Okay, I'm staying then. All right.
Hey, thanks so much. Thanks so much, Steve, for that really entertaining and interesting talk. I feel like it had a lot for all of us, faculty, students, and industrial partners. I know for me, it raised an immediate question. Andre passed 130A off to me, so now if I throw a marker at somebody, can I look for you for representation if there's some, okay.
I'm not licensed in California, but if you come to any of the states I am, I got your back.
Okay. Okay, but in all seriousness, now we're going to do a little Q&A, so
Yeah,
if anyone has
great.
any questions, please just raise your hand and let's chat with Steve while we have him. Maybe start with Z.
Sure. Thank you for the...
Sure, yeah, maybe you can repeat the question.
Oh, I'll repeat the question. Does
After
that
he
work?
says,
Sure.
yeah.
I'll repeat the question.
Thank you for the great talk. So we're at university and so are you. And university typically have international community. So when you start by saying, what does being American mean? So do you believe that the amendment, the Constitution Amendment, apply equally to permanent residents and other citizens who happen to be here legally or undocumented?
Yes. Well, so I'll tell you I can tell you the legal answer to the question first, which at least because I matter little, the United States Supreme Court matters a lot, but it's a very important humanitarian question, right? So very, very important on every level. I can tell a happy story at least as to part of it. Oh, repeat the question. Repeat the question. I already failed. I failed the test. Thank you. Yeah. So thank you. So the question is, I started with Americans, of course, in American law. What about international students? People in this country, international people for all sorts, right? On green cards, on visas, on every other way that you might be in this country, including potentially illegally. So there's a lot of ways people can be in this country. Well, for those first all categories, the law is this. There's a Supreme Court case called Verdugo-Urquidez. And in that case, the Supreme Court basically said to have these constitutional rights, you do have to be part of our national community. But it was an extreme case where this guy had absolutely no part in our national community. In fact, he was only here because he very much didn't want to be here. They had gone down to Mexico and forcibly extracted him to try him here because he was involved in crimes, okay? So he had absolutely no lawful connection whatsoever to our community. And they did say in that case, then you do not have all the constitutional rights. But let me be careful here, too, because I started by saying the Fourth Amendment is an anti-accuracy right, pro-liberty right. I would still like that to give that to everybody because it is a dignity-promoting right, of course, and a humanity-approaching right, but we might be able to do things in the collective. There are other rights that are even more important because they're accuracy-promoting rights. So due process of law, you get an attorney if you're prosecuted with crime. These sort of rights in our other amendments you absolutely have to give to anybody. I don't care why they're here, because the whole thing you might be trying to resolve is whether they're here lawfully, what are the laws, and how it applies to them, and they absolutely need all those protections, right? Because otherwise we get the wrong answer for sure. So the Supreme Court, for what it's worth, I'll stick to kind of the law of it, the Supreme Court does divide those a little bit. It's good news for everybody who has any lawful connection to this country. I will say, with respect to current Supreme Court precedent, it is probably not good news for people here illegally. And because also the Fourth Amendment, there's something called the exclusionary rule. I won't go into too much about it, but we suppress evidence in criminal trials as a way of deterring the police from doing wrong in future cases. We typically don't apply that, for instance, in deportation proceedings and other cases that are not criminal. So it's a mixed message, but I will just say what I wanted to focus on most of today is, of course, the founding principles have been a light to the world. We Americans get so much wrong, and by God we do, right? But we still get some things right. And I just wish we could all still remember both of those things, right, when we're all talking about all these things. Because the principles of the founding Constitution that are beautiful are in our Bill of Rights, and they have been shared by much of the world, right, in sense. We were the first one to write them in a Constitution. We didn't develop them, we just stole them. That's the great thing about ideas, right? You're allowed to steal them. You're supposed to take all good ideas. And so we put them in this Constitution, and they did a lot of good in the world, even though we can keep doing better. And we always have to keep trying to do better. But there is reason, I guess, again, it is the American civic religion to me. The Constitution, the Bill of Rights. We Americans, we don't share maybe a lot of things we used to share, but we do share that. And I just hope if we, and I do think anyone here, because you're our friends, you're our neighbors, we care about you as people, I certainly think of sharing those things with them, whatever the United States Supreme Court may say, because those to me are our founding values that I think we do all share together, and we would wish to see a world where it was that way everywhere. Hope that answers the question.
Yeah, maybe right here. I think you had your hand up.
Sure. So, two-part question. You talked a little bit in the cases you showed the gap between when the first sort of precedent to the one in 2012.
Yes, in 2018. Yes.
So there's this gap, and I also understand the conservative movement. It doesn't change very often. Is that gap shrinking, and the pace of technology is moving even faster?
Right.
Do you see that getting out of control? What are your thoughts on some of those things?
Great question. No, it's tough. It's really tough because a lot of people would criticize the courts. I mean, look, that third-party doctrine, here's what happened. They didn't apply it in basically 50 years. They set the whole thing up, and then they just never applied it. They didn't take the cases weren't coming before them. So I think it did take too long, and that can be a legitimate criticism. So like so much in life, right, the hard thing in life is it's always, this is true, but that's also true. In law, I think we don't want to move too quickly. The law, there's famous quotes that will say things like, lest we embarrass ourselves, right? You guys are creating technology so fast that if we try, especially we lawyers who don't know quite what you're doing, right? We don't get it. We don't quite understand it. If we try to develop the law for what you build today, well, tomorrow you've already built something even better, and we may embarrass the future, it is said, by forging our laws now. So we have to be aware of that. At the same time, we have to do a better job to be faster. I think one of the ways is some of this people who take both, right? I think encourage anybody, if you ever want to be a lawyer, if you want to go into any of these fields, politics, make a difference, you can do it with your engineering degrees as well. I know a lot of you do, right? But whether it's just pure research or not, because we need more of that. We need more of people understanding it, because then I think they can make those changes a little bit faster. But it'll always be that tension trying to hit that perfect sweet spot. Don't go too fast, right? But just fast enough. This one took too long. It did.
So my question is, two-part question actually. The first part is, what's stopping, say, if the judge would allow a lawyer, a public defender to use the AI today?
Yeah.
He's already barred. He's got the bar or
Right.
license or whatever.
Right.
And then second, what's your sense as to the level of AI to put on a good defense versus the below average or average lawyer today?
Great questions. Now I remember to repeat them, so I'm not going to fail again. Thank you. Sorry. So first of all, why could a defense lawyer use AI today? Very interesting question. We have a whole field of professional ethics, obviously, as well in the law, so we think that we are the only people that can regulate ourselves. It's kind of a nifty system if you think about it. But in any event, hopefully there's some good to it. We have this whole PR system and professional ethics. They're working with that now. The answer is they absolutely can do it. There's nothing stopping it, but you have to think about a lot of things. Confidentiality, like in your contracting and this stuff, very important in law. So obviously we can't be feeding things into a public version of ChatGPT because that may be our client's confidences. So we have to worry about boxing those things, so we build those boxes. If you build those boxes, you can definitely do it. You just have to do all the things you engineers would do. You take the good answer and then you verify it yourself. Where law has embarrassed itself to date is, of course, hallucinations, right? So there's famous cases already where people are giving the judge citations where the cases don't even exist. And so that does not go well, and it embarrasses not only you, but obviously it's very bad for your client. So the answer is there are ways to do it, but they're still building. They're still figuring out how to black box those systems, and then say if you are Kirkland & Ellis, right, a law firm that's happens to be the highest grossing firm in the world right now, are you going to build your own black box? Are you going to work with ChatGPT or Claude or somebody else? So it's all really in development, so they could do it. So that's the first part. It's in flux, but they could do it. As to how good they are compared to the current attorney, because of the ridiculous caseloads that attorneys have to deal with, it actually would be a huge help. I wish it were not so, meaning that we had great attorneys everywhere all the time, but they just cannot be, even if they were their best sort. They do not have the time and what they would need. You know, they're carrying hundreds and hundreds of felony cases a year in these public defender's office, and if you start computing the amount of hours you could give to each person, and every one of these people, their entire life is on the line. You have to remember that that's someone's son, that's someone's daughter, that's someone's mom, that's someone's dad, and if it was your son, daughter, mom, or dad, you would want somebody, whatever they've done, right, to be there and do that thing, and they just can't. So even as they are, there would be a tremendous help, but we do have to seriously work on, obviously, the hallucination problem. So, you know, we need to know it's credible law. When it gets it right, it's getting very good. But right now, you still got to check everything, as you well know, in the engineering as well, because sometimes it's wildly wrong, if that answers it at all. Yeah. They can pass the bar exam, you know, and all that. I mean, they do. They can pass all the legal licensing exams, probably in engineering as well. I don't know, but in law, yeah, they can pass all their stuff. I mean, they're getting really good.
Suresh, did you? Yeah, I really enjoyed your presentation. Excellent, thank you.
Thank you.
I have kind of a more philosophical question. You know, there's nothing interpretable or subjective about Maxwell's equations. It works the same way, no matter what religion, what country you're in. The Supreme Court is basically the basis of the law, and there are a lot of subjective decisions, and historically, there have been many really bad ones that have impacted people for generations. And the question is, the pace of technology is going, but it seems that the pace of review of Supreme Court cases and the evolution of the jurisprudence is still the same. Do you see, with kind of the diverse society that we have and technology that we have, that changing anytime in the future in terms of how the Supreme Court looks at issues of great importance, including things that they may have gotten wrong to try to correct?
Yeah, thank you so much. Such a rich question. Such a rich question. I'll try to repeat it kind of as I go for the recording as well. So one thing I'd like to focus on, there is one answer in my area of law that's supposed to be very hopeful again, which is, of course, that we actually don't rely on the United States Supreme Court. You know, and then I'll get to your bigger question, which is so good. But it is important to realize in criminal justice, right, because that's what's so unique about this country. The jury is amazing, right? The idea is the jury is supposed to be, in the Supreme Court's own words, the circuit breaker in the state's machinery of criminal justice. In other words, there is no prosecutor in this country anywhere that can get a criminal conviction unless the people decide to do it. That is remarkably democratic. You know, classical Athens was even more democratic than we are, but that is remarkably democratic. So one thing we could do, but I don't see it happening, but I'm trying, and other people are trying, that actually would change the world, right? Now, it would not be right. It would still be subjective, because one thing you pointed out, right, is in engineering, if you're right, and if, of course, there is a third chance, says Phil Bostrom, we're living in a simulation. So it's hard to know, you know, how much any of this is purely objective. But It still wouldn't be that, but it would be role reversible. It would be different. All I'm saying is it would be different. And so someone like me who believes that that intrinsically makes the decision as right as human decisions can ever be, at least there is a system in place for criminal justice, we could do it. As for writ large in the law, again, law moves slowly, right? I mean, we don't have video recording in the Supreme Court. That is always controversial. It comes up again and again and again. Some people love keeping it old school. Some people are upset about it. But now we finally get release of audio transcripts, so you can listen to those and put them on there. I don't have the answer. I will just say this: as a student of philosophy, as a student of history, as a student of world religions, as a student of all those things, there's never been a time we have had all of it. We just haven't. Every society has set up ideals that it failed itself to live. I think every religion and church has set up ideals that it fails to live. I think every philosophy set up ideals that it fails to live. So all I'm saying is I think it's hard. To me, what I always try to impress upon my students and what I would hope to convey to you students is that we are defined by the attempt whether or not we succeed. And that's something you can do every day. There's one thing about defense attorneys, for instance. If you're overworked or you're underpaid, there's one thing you can do every single day. It's that you can treat your clients with human dignity and respect. And nobody can stop you from doing that. It doesn't matter how hard the case is. It doesn't matter how complicated it is. It doesn't matter where you got trained. It doesn't matter anything. And you guys will be able to do all the same thing for your clients in the technology sector. Everybody is a human being that you're dealing with and that your products are going to be dealt for. So I know it doesn't answer the question, but to me, that's what we could strive for as a people. It's a process. We'll never get it right in the end result, but we could always improve the process. Such a good question, so I don't have a better answer.
This might be a little philosophical, but you stated that AI fails the role reversibility test for being a prosecutor or being a judge because it's not imperiled in the same way that the judge would be in that same situation. So given that fact, is AGI actually possible?
Well, wonderful question. So he's saying, yeah, if I want role reversibility, is AGI really possible? So I think this answers your question. I'm ready for robot prosecutors and judges, which we develop out more if I had time, when we have robot defendants. In other words, then they truly would be part of our polity, right? They would be reciprocally vulnerable to the same punishments that they give, and at that time, I would be ready to turn over my judgment to a robot. Because I think the theory would be, if you're not speciest, you could say, but for the grace of fortune, there go I, right? And this gets it. I mean, it's very interesting. That's kind of stuff. It's such a great question, but that's the nerd answer I'll give you, and I really believe it. I am not threatened by our brave new world. I hope you build it. I hope you build it. Because the great questions of humanity, it is philosophical. This is what Socrates wanted to know. This is what every philosopher living, Spinoza, anybody you like, wanted to know. Who are we? What are we? Where are we going? And if you can build in silicon what happens up here in our own neural networks, and it starts telling us it's conscious, and it has belief systems, and what about it? And does it have rights? And what about its Fourth Amendment rights? Are they written in our Constitution? I hope I live to see the day, because I think it'd be very exciting to tell us more about who we are. And I don't mean to upset anybody's personal religious convictions in that, but I think they could just add, right? Knowledge adds to whatever you have, and I think it would enrich it. So I'm ready for it, but we got to build it, and then they would have to become genuine members of the polity, which would be fascinating.
Saeed?
Yes.
The kind of background you have, degree in STEM field and then subsequently law here, degree in law, probably is very important for this kind of discussions in policy making. Is there anyone in the Congress now, senators or the Assembly members, the House members who have similar kind of background?
That's a great question. So he's asking, are there people in our Senate, in our House, who have this technology background in a STEM field they're bringing to it? Wow, see, but I'm seeing head shaking. No, I mean, I'm going to express my ignorance here. Here's the problem. This is because, I mean, who does? Can we think of a good person? We can crowdsource it here. Is there a person who brings that? I mean, I think we have doctors, certainly, right? Medical doctors. Yes. Lots of lawyers, yeah. Now, interestingly, and this is interesting, you know, in state legislatures, there tend not to be lawyers. So it cuts both ways. I think it's bad to have too many lawyers. It's actually pretty bad not to have any lawyers, too. There are state representatives that don't have any lawyers. And then, you know, when you're crafting laws and you're supposed to understand how the system works, that's a little weird, too. So probably some healthy medium there. But I can't think of it. And this is probably my own ignorance. I'm going to go do my own homework and think more on this. But we should all be able to name that person immediately. You know, him, her, this person, that person, these people, because that's what we need, right? And, you know, here's what upsets, I think, everybody in the room. We have intergenerational room here. They're not really talking to each other about anything. And that's, I think, what upsets Americans and everybody in the world. We have very strong feelings. I have very strong personal convictions about many things. But I dare say, I think I could talk to each and every person in this room, and I would enjoy the conversation, right? If we can do it, they can do it, right? But I don't know. We got to teach them. But that's a great question. And just the fact that we can't immediately name them, I think, shows we're failing in that. And we need to get those people there that are making those decisions. Because I agree with you. Today, if you don't understand all these great questions about how fast technology is changing and what is real and what is not real, and every time I read an article that I do know something about, and I'm thinking, that's not accurate. You know, that's not describing what the science is really doing. And I can do it in law because I know that's not accurately describing what the law is doing. We need people to explain it to judges, to juries, to every person. So we need to do better. I don't know what to do about that. So you guys back there, politics for one of you.
Okay, yeah, I think, well, maybe on that note, just one final question,
Yeah.
maybe from me. I'm going to selfishly grab the final question. So you made a pretty big pivot in your career, and maybe I missed it, but what was it that inspired you to go? It seems different than the direction for other members of your family.
Right.
What was it that inspired you to go in this direction?
So I always knew it's what I wanted to do. So in some sense, it was weird I went into double E at all. But my dad is a physicist, my brother's a double E, my sister's a computer science major, et cetera, et cetera. Oh, we're done. Okay, so, but I'm still going to answer the question. So here's what it was for me. And this is what I think if you haven't yet set your career path, anybody who hasn't, or maybe we've not ever set our career path entirely, right? I loved the questions of engineering. They fascinated me, and they still do. Why I love Maxwell's equations is because to me they're beautiful. And if they're not beautiful to you yet, you should work and strive until you see them as beautiful. Because the physics and reality of this universe, even just the bits we know about it, is beautiful. It's amazing, right? And so I love that aspect, so I knew I liked that. But it wasn't my passion. It wasn't my drive. It was for my family members, but I knew it's not what I wanted to get up every day the rest of my life and try to make a better world. I will admit I was very optimistic. I was very naive probably too. I was very young, okay, once. We all were young once. But that's the beauty, right, to me, of being young once. I had dreams. I wanted to change the world. I haven't really, confession time. But every once in a while, good friends still remember that you came, you know, and that's special. But most of us don't really get to change the world, but you do get to change yourself each and every single day. So for me, that's the thing. It was criminal defense. I knew was my passion. I would not be fulfilled as a human being if I had just done engineering. So that's what you ask yourself, I think, right, is what fulfills you as a person, not just in learning in the classroom, but what do you want to do in the precious few years that we are given here? And then you just embrace it. I've had a good time. I've had a great family. I've had the little things that make life good. And I know I'm pontificating and speechifying a hell of a lot up here, so you'll forgive me. But I guess it's the day that's got in my blood. But I will just say the one thing. It is those little things, right, that are going to define your life. I'm still young, but I'm 50 years old, so I'm about medium, right? And the more years you go on, I don't know. I am mocked by these people here because I was prone to saying at one point that I did want to be president of the United States. I told you I was young once, right? And that was good. But you know what? I don't want to be that anymore, and that's fine. But I wouldn't give up any of these little moments. It's the little moments, I swear to you, that you're going to remember, anybody who is still younger than me, when you're going to look back and that are precious. So just find a field that speaks to your heart, and you will have a wonderful, rich life. It's not all about this kind of richness.
Well, let's all thank Steve for sharing this moment with us.
Thank you.